Hello, KSCPA members. I'm Natasha Schamberger, and I'd like to welcome you to today's Expert Forum virtual Q&A. And so we'll be focusing on the new rules for FMLA and paid sick leave. There's a lot going on right now, so I hope you are all hanging in there okay. Just to give you a brief overview of what you can expect from today's virtual Q&A. First off, we'll have our experts give us an overview of the new rules and what that means for you. In order to facilitate a good listening experience for us all, you have all been muted. And so the way that we're doing it is that you can ask your questions using the chat feature. And so you'll see a chat icon at the bottom of your screen. So if you click that, it'll open up your chat box. And you'll be able to type in any questions that you have there. Now, we have received quite a few questions on Friday and today, folks that wanted to submit them in advance. So our experts are going to tackle those questions probably first, and then any additional questions that come in and pop up in the chat box, we'll keep those build those in at the end of the discussion as well. For the best viewing experience, I suggest that you make your setting set to speaker view. That's in the upper right-hand corner. That way you're only seeing the person that's doing the speaking. We've reserved an hour. And so if we do not get out to all the questions, we'll keep tabs on that and we'll figure out how to address those afterwards and send out a video summary or host another virtual forum. So in addition to that, we are also recording this virtual Q&A, and we'll distribute it out as well. So with that, I would like to introduce our experts today. First off, we've got Eric Namey, who is an attorney with Hinkle Law Firm. He heads the Taxation, Employee Benefits, and Employment Law Practice Group. He's practiced in employee benefit matters for more than 33 years and has also represented clients before the IRS for more than 35 years. Eric is a CPA, and he's been an active member of the KSCPA for many years, and he also serves on our Kansas Tax Conference Steering Committee. In addition, we are also honored to welcome James Spencer, aka Jim. He's also an attorney with Hinkle Law Firm and helps his business clients manage their workplaces with respect to employment law, executive compensation, and employee benefit matters. So with that, we are honored to welcome both Eric and Jim. Gentlemen, the forum is now yours.
Well, thank you. Thank you. We appreciate the opportunity to be with all of you virtually. I wish I could see your faces just so I could see if you're snoring or not. But this is an area where you definitely want to, I guess everybody wants to pay attention. We've been dealing with this extensively, and my area of practice is primarily tax and employee benefits side. Jim Spencer, who's joining us, is primarily in employment law, executive compensation in that world. And so he will end up doing a lot of the heavy lifting today on this webinar. I will be involved to the extent that employee benefit matters come up, and they do, and tax matters, and chime in. But Jim's going to, based on the questions and what we've been getting, he ends up having to do a lot of the heavy lifting. I think you received some alerts that we put out over the last week that have been well received. I think it's triggered about a phone call every 30 seconds. So hopefully a lot of your questions we've seen, and they're good ones, and we are looking forward to answering them and the additional ones. But I'm going to turn it to Jim and let him sort of do the overview of where we're at in guidance and direction, and I'll chime in periodically, and I'll mostly, just like I said, focus on employee benefits. So Jim, we'll turn it to you.
Thanks, Eric. So the topic that we're going to be answering questions on today is the Families First Coronavirus Response Act, which the President signed on March 18th, and which takes effect 2 days from now on Wednesday, April 1st. Initially, there was some thought it would be April 2nd because Congress said that the statute had to take effect no later than April 2nd, but the actual effective date is April 1st, so keep that in mind. I've still seen some questions and that sort of thing that make it sound as though people think it's April 2nd. So what Congress did, and this legislation was thrown together very quickly, and they're leaving it to the Department of Labor and to the IRS to kind of flesh it out through regulations, and we're still waiting on regulations from DOL and the IRS. Thankfully, both agencies have issued some preliminary guidance. While not regulatory, it's very helpful in understanding how this law is going to work, especially since it takes effect in 2 days and people are scrambling right now. So what this law does is it requires most employers to provide paid leave for coronavirus purposes. So when I say most employers, it definitely applies to any private employers that have fewer than 500 employees. So large companies are not subject to this law, but those who have fewer than 500 are. And if they have fewer than 500, then they have to provide their employees with up to 80 hours of paid sick leave if the employee is unable to work or telework because the employee, him or herself, is subject to a federal, state, or local quarantine or isolation order related to COVID-19. This is not talking, by the way, about a stay-at-home order, okay? Stay-at-home order is not employee-specific. This is talking about an employee-specific order that is to quarantine or isolate. For instance, we know that the KDHE and the governor have issued orders regarding, I think it's just KDHE has issued orders regarding employees who have, or people who have traveled to certain parts of the country during the last X number of days. They're supposed to stay at home. Okay, so that's a state quarantine or isolation order that this would apply to. And in that situation, the employer has to provide the employee with up to 2 weeks or 80 hours of paid sick leave. Also, if an employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, that qualifies for the 80 hours of paid sick leave. Now, this does not mean that if your employee just decides, hey, I'm afraid I'm going to get coronavirus if I come to work, so I'm going to stay home. That's not what this is talking about. This is talking about a healthcare provider like a doctor or a PA actually advising the employee in writing and having the employee then provide that documentation to the employer that the employee needs to self-quarantine because of COVID-19 concerns. If the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis, then the employee is entitled to the 80 hours of paid sick leave. If the employee decides that they need to stay home and care for any individual, whether it's a family member, a next door neighbor, their worst enemy, whoever it is, if they decide that they want to stay home and take care of somebody who's subject to a quarantine or isolation order or has been advised to self-quarantine by a healthcare provider, then the employee has the right to the 80 hours of paid sick leave. If the employee is going to, like for instance, has children that were in school, but now the schools are canceled or closed, then they can get the 80 hours of paid sick leave to stay home with their kids. Or if the child care provider that was being paid, we're not talking about an unpaid child care provider like a grandparent or somebody like that who was just watching the kids because they love them. But if you had a child care provider who was being paid and is no longer available or is closed, it's the same deal. The employees have the right to take the 2 weeks of paid sick leave. Now I mentioned that this is a requirement for private employers with fewer than 500 employees. This also affects most government employers. Okay. Now that's the first part, the first thing that the statute did. The second thing that it did was it amended the Family Medical and Leave Act, or as we refer to it, the FMLA, to require most employers to provide 12 weeks of job protected leave if the employee needs to stay home with their child because the paid provider is no longer available or the school is closed. Okay, so that's one of the things that you can also take paid sick leave for, which means that if you got somebody who right now has their kid at home and they need to stay home with the kid to help them homeschool or whatever, and there's no way for them to work at home, then the employee could take 2 weeks of paid sick leave in conjunction with the first 2 weeks of FMLA leave, and then take an additional 10 weeks of FMLA leave. Now, the thing that is very different about this law, one thing that's very different about this law is that this is the first law that I'm aware of, at least on a federal level, that requires the employer to provide paid leave and then get reimbursed from the federal government, okay? So like federal contractors have been required for a number of years to provide paid sick leave to their employees, but that's on the employer's dime. This particular law is requiring employers to provide the paid leave and then allows them to get a tax credit against their pay, against what they've paid. And the way that the IRS has said this is going to work is that the employer can actually take the credit when they make their federal tax deposit. So a lot of employers are making their tax deposits on a weekly or bi-weekly, some of them monthly basis, but whenever they make those tax deposits, they can offset the amounts that they've paid for this paid leave under this new law against their payroll tax deposit. And it's not just the Social Security part of it, it's the federal income tax, Medicare, and Social Security. They can offset it against the whole thing. The Department of Labor, as I mentioned, has issued some guidance. They've issued FAQs, and it's on their website. They first issued the FAQs last week sometime, and they started off with like, I don't know, 25 or 30 FAQs. And then we turned around, and the next day they'd issued a bunch more, and then they issued a bunch more. So they keep updating the FAQ page. So if you get onto the Wage and Hour Division's page for this pandemic, you're going to find a link to their FAQs. And if you read them today, just be aware that they might change tomorrow. They might change the ones they've already issued, or they might add new ones. But those FAQs,
I might add, they don't put them in red line format, so you have to go back and read them again because you don't know what they changed.
Yeah, you see, so we've got an alert that we've got a tracking thing set up on their website, and so it tells us every 3 hours whether or not the Department of Labor has changed things. Now that emergency FMLA leave provision that I mentioned, that also applies to private employers with less than 500 employees, as well as government employers, regardless of the number of employees, and private and public elementary and secondary schools. If you're at all familiar with the FMLA leave, you're used to a rule being in effect that says, okay, look, in order to be eligible for FMLA leave, you have to meet certain conditions, like you have to have worked for the company for at least a year, you have to have at least 1,250 hours, and you have to work at a work site that has at least 50 employees within 75 miles. Those are off the table as to this new type of FMLA leave, okay? The only thing that the employee has to satisfy is they have to been employed with you for at least 30 days as of the date that their leave starts. So you could have an employee who is eligible just for this new type of leave and not for any other type of FMLA leave, okay? That's a decent summary, I think, of what this law does. Now we're going to go ahead and start rolling through the questions that were submitted ahead of time. And hopefully we'll have enough time to get through these. There is a place in the chat where if you got some questions that haven't been asked already, you can ask those and we'll try and get to those. Okay, first question is, are employers required to pay employees in the event of business closures, furloughs, or reduced work hours as a result of state or local government quarantine isolation order? The answer to that is no. You're not required to pay somebody for not working, and they are not eligible for paid leave unless you actually want them to be at work and they're taking leave. So that's one thing to kind of keep in mind is that if you want to have the employee at work and they want to stay home, then they may be eligible for the paid leave. Just depends on whether they want to stay home for the right reason. But if the reason that they're staying home is because your business is non-essential and you've closed, or you just don't have any business anymore because of the pandemic and you've sent everybody home, they're not entitled to take paid leave. In that situation, the next question here is, can employees apply for unemployment in these situations if they're not receiving other forms of paid leave when not working? And yes, they can apply for unemployment. In fact, even in a reduced work schedule situation, they can now apply for unemployment. And the state of Kansas has waived the normal waiting period between when somebody has to lose their job or have reduced hours and when they can start unemployment. So people can start getting it right away. Next question, do any provisions of the CARES Act change the Families First Act? Now, the CARES Act is the law that was just passed by the Senate and the House, and I think the president signed it, although I've kind of lost track. But that's the 800 and some page law. I haven't read it. I don't think Eric's read it. We're not aware of any provisions in that law that would affect the Families First Act, though.
No, I actually have read it, and
all 800 pages
over the weekend, and I don't think that the two acts kind of act independently.
Okay. Next question. If an employee missed work due to a valid Family First Act reason before April 1st, but is paid for it after April 1st due to the pay period it occurred in, are the wages eligible for the act/credit? The answer is no. The only leave that you can, that falls under this new law is leave that is taken on or after April 1st up through December 31st of this year. So if you have people that were taking leave, say today, that's fine. You can provide them leave today and you can pay for it, but it's not going to count against their leave allocation under the new law, and you can't get reimbursed by the federal government for what you pay in wages. The next question has to do with the tax credits regarding the credit for employees who are not able to work due to their child's school or daycare being canceled. For an employee that normally works 40 hours per week, is it possible for an employee to work part-time, for example, 20 hours per week, and the employer still be eligible for the credit for the other 20 hours that the employee can't work? Parents that are now also expected to be their children's teachers at home and now also work from home may not be available 40 hours per week to dedicate to their job. Okay, so what this is basically asking is, do the employees have to take this type of leave in full day increments, or can they piecemeal it? And we call that taking it on an intermittent basis. The answer is that the employees can take it on an intermittent basis if the employer agrees. So if the employer is willing to let them, work for 2 hours at home and then homeschool for 3 hours and then get back online and work for another 4 hours, that's fine. You can make that work. You can do that. And notice, though, that I said that that's for this is in the context of the child care leave. And that's either under the FMLA provisions or under the 2 weeks of paid sick leave. If somebody is taking paid sick leave for any other reason, like for instance, they're sick or they're self-quarantining or they've been ordered to quarantine, they cannot take any of this paid leave intermittently, okay? Next question, could both parents that work for two separate employers both take off work because the kids are out of school, and would then both of their employers qualify for the credit? I haven't seen anything that would say, no, you can't do that. So I think that if you got mom working at company A and dad working at company B, and they both want to take time off, to stay home with the kids, I think that that's permitted under the law, and both employers would be obligated to pay the paid leave and could then get a tax credit. Can parents take turns taking off work during the 10-week period that their kids are out of school and have the days that they each take off qualify for the credit under the new law? And this goes back to the intermittent leave. If the employer agrees to allow that, then yes, they can do that. Are the wages paid under the new law subject to normal tax and benefit withholdings, just as normal wages are, such as withhold Social Security tax, Medicare tax, federal tax, state tax, employee portion of benefits? Eric, I think this one's for you.
Yes, the answer is yes. It's wages. It's wages, it's leave, it's wages, it's subject to taxes just like any paycheck.
Are the wages paid under the new law eligible for employee pension plan profit sharing for 401k match?
And yes, I think it's the same question. If they've got 401k deferral elections made, they're getting in their pay, a paycheck, they would apply unless they revoke their election for this period of time. And if they're getting some percentage of pay into a retirement plan, this is compensation. It would meet the definition of compensation under most plans that I see, unless somehow the plan specifically excluded it from the definition of compensation.
So just as a general rule, this paid leave is treated just like paid leave that's normally provided by an employer?
Yes, it's W-2 compensation from everything we can tell.
Okay. Next question. I have clients that have professional offices such as optometrists and dental offices. It has been mandated for these types of businesses to discontinue routine services. These businesses are having to reduce their employees' hours due to lack of work. If those same employees have school-age children that now need homeschooled, are the sick wages paid to these employees still eligible for the credit, even though that isn't primarily why they are not able to come to work? So if you got an employee whose hours have been reduced, they cannot take the new paid leave in order to fill up the tank. In other words, they can't use it to replace the hours that got reduced. So if somebody was working 40 and you only need them now for 25 hours a week, you're going to pay them for the 25 hours that they work, but they're not eligible for 15 hours of paid leave under this new law. The key to remember with this new law is that the only way somebody can take leave is if the employer wants them at work and actually has work for them. So if the employer has closed up shop or reduced hours and that sort of thing, then paid leave is off the table. Do the new rules for FMLA small businesses apply only to non-essential businesses? This is kind of a confusing question, simply because non-essential businesses has to do with the stay-at-home orders, and the new law doesn't say anything about non-essential businesses. They do have some rules that when Congress passed the law, they did say that the Department of Labor could set rules that would exempt small businesses from some or all of the requirements of the Act. And by small businesses, they meant businesses with less than 50 employees. And the other day, I think over the weekend, the Department of Labor issued the criteria for this, and they said, look, if you're a small business with fewer than 50 employees, and the employee is taking leave or wants to take leave because of a school closure or the child care provider is not available, then you may be exempted from providing them with the paid leave. And there's three things that you have to look at. And if any of these apply, then you don't have to provide the paid leave to the employee. First of all, if the provision of the paid leave would result in the small business's expenses and financial obligations exceeding the available business revenues and causing the small business to cease operating at a minimal capacity, you don't have to provide the leave. So if it's creating significant financial distress on the financials, you don't have to provide it. Or if the absence of the employee would entail a substantial risk to the financial health or operational capabilities of the small business because of their specialized skills, knowledge, or responsibilities, you don't have to provide the paid leave to that person. Or if you don't have sufficient workers who are able, willing, and qualified and who will be available when needed to perform labor or services, then you don't have to provide the paid leave to those people. So there's some rules there, but again, it has nothing to do with whether the business is essential or non-essential. Next question. With Shawnee County and several counties in Kansas currently having the stay-at-home order, and actually now we've got a statewide stay-at-home order from the governor, does this stay-at-home order qualify all non-essential small businesses to follow the new FMLA guidelines? Okay, so I think what this is asking is, if you're non-essential and you're closed up, you have to follow the new FMLA guidelines. The answer is no, you're not going to be providing leave under this new law because your business is closed. Now, if so, I mean, if your business is still open and from the standpoint that people can work from home and they then need to take leave, because they can't work full time from home, that may be different. But if you're having to close because of the stay-at-home order, paid leave is not going to be available to your employees. If they send employees home, this is another question. If they send employees home because they can't be open as a non-essential, does the employer start paying FMLA sick pay? No. Or does this fall under layoff and the employees file for Kansas unemployment? Yeah, I would recommend that they file for unemployment. There's a lot of people doing that right now.
Hey, Jim, a question. You used the word layoff. A lot of people have been asking about furlough, the word furlough and the word layoff. Is there a distinction in your mind from a legal perspective?
Yeah, there's no distinction from a legal perspective. I think layoff and furlough may mean different things to different people. Had a lot of clients decide that they're going to send people home for the time being, and they decided to call it a furlough because it sounds less permanent than a layoff. But from a legal perspective, there's just no difference. This is another question. If a nonprofit has been mandated by the state to close well before the effective date of the act due to COVID concerns, are they eligible for the FMLA credits? Again, the answer to that is no, because any leave provided prior to April 1st is not available for the credits. Plus, we're talking about a business that closed, and again, the paid leave is not available. Next question, very specific industry question. Veterinarian services are considered essential, but what about their grooming services they provide within their vet clinic? Do the grooming services fall under vet services and thus essential, or do they fall under personal services that are non-essential? Currently in Shawnee County, all hairdressers are closed for a month with the stay-at-home directive as non-essential. Is pet grooming the same? Answer to that is I have no idea. It has nothing to do with the paid leave, and so it's just not something that I'm familiar with. And Eric, or you know the answer to that?
I don't know the answer.
Okay, so we don't know. But keep in mind though that Kansas now has their stay-at-home order, which supersedes for the most part the local and county stay-at-home orders. Next question, will this apply to businesses exempted in the local stay-at-home order, of which there are 10? Well, it does apply to them, but as I've said, if they're closed because of the stay-at-home order, there's no paid leave under the new law that people can take. What about employees that choose to stay at home or chose to stay at home from work before April 1st due to a stay-at-home order, even though their job was an exempted job? What is the employer requirement, and are any of the credits available? If they were staying home before April 1st, there is no paid leave available. There's no tax credits available. Now, if you've got an employee who's staying home because they just don't want to come to work, and you want them at work and they have no leave available, then you can, of course, discipline them or terminate them. Next question, will the March 31st, 2020 941s be affected by any of this? Eric, you're the tax guy.
Certainly the credit will be taken on the 941. There'll be some place on it to do that. Obviously you're reducing your deposits at every pay period by the amount of the sick leave and FMLA leave that you're paying, and you're reducing it, and then ultimately there'll be a place to reflect it on the 941.
Okay, is the due date been changed?
I don't think 941s have been, the 331, 20, 941s have been changed. It was income.
I don't think so either. I know the income tax returns have
just
been.
Income tax return.
Okay.
You're going to want to file these. So.
If a restaurant shut down prior to April 1st and some employees applied for unemployment, are they then required to start paying any wages when we get to the pay period, including April 1st? Again, no, assuming that the restaurant remains shut down, as long as the store is shut down and the employees can't work, there's not going to be any paid leave available under this law, although I imagine unemployment is still going to be available. Further question on restaurants, does the 2/3 pay include an estimated tips amount for tipped employees, or do you just pay out at minimum wage for their estimated hours? Okay, this is something I haven't mentioned yet, but there is a distinction between how much money you have to pay for the different types of leave. If you've got somebody who is taking the leave, whether it's under the 80 hours of paid sick leave or under the 10 weeks of paid FMLA leave, that's going, and they're taking it because of childcare issues, that's going to be paid at 2/3 of the employee's regular rate. And it's got to be 2/3 of the regular rate. But if that's less than minimum wage, then I think you've got to pay them the minimum wage. If you are taking the 80 hours of paid sick leave and it's for yourself, for instance, the employee is quarantined or subject to self-quarantine or going to see the doctor to get a diagnosis, that's going to be paid at 100% of their regular rate of pay. If they're taking the 80 hours of paid sick leave to take care of somebody else, including their kid, then that's going to be 2/3 of their regular rate of pay. Lost my place on the question sheet. What if 2/3 pay is below the minimum wage? I think what the Department of Labor is saying, and I've looked at the FAQs, it was a little unclear to me, but I think what they're saying is you still pay out at minimum wage if the 2/3 is less than minimum wage. Next question, if the employee can telework, but has kids at home and supervising remote learning, can the employer pay 4 hours at 2/3 rate and 4 hours at full pay for the worked hours so the parent has time to help with school? Yes, the employer can do that. And again, the child care leave is going to be at 2/3 pay. And if, and you can do that intermittently as long as the employer agrees to that. Next question. What if an employee can perform some, but not all of their duties from home? Can they receive the 80 hours sick pay to make up their regularly scheduled hours? So if you've got somebody, well, one thing to keep in mind, and the Department of Labor makes this crystal clear in their FAQs, is that employers are not required to allow their employees to telework. Okay, there are some jobs that telework just won't work at all for. I mean, like if you're on an assembly line, you can't really do that job from home. There are other jobs where it's also difficult, if not impossible, to do, either because of the job duties or perhaps because the employer wants to be able to supervise the employees. This law is not forcing employers to start allowing telework unless they want to. So if you've got an employee who can perform some but not all of their duties from home, I guess that means that they're at home and maybe they can do half their job, but the other half just can't be done from home. Can they receive the 80 hours of sick pay to make up their regularly scheduled hours? Well, it sounds to me like if they're working from home and half the time they're just not able to work, that would be a reduction in hours. So they're not going to be able to take paid leave to cover that. Next question. If an employee can telework but has kids at home and supervising remote learning, can the employer pay 4 hours at 2/3 pay and 4 hours at full pay for worked hours so the parent has time to help with the school? I think that's just a duplicate question, but yes, you can do that as long as the employer agrees. Do governmental entities, such as cities, get the wages that are paid under these new rules back as other entities do through not paying the employer's share of the Social Security tax? Eric, do you remember the answer to that? I recall having a question about that. It was a little unclear to me.
I don't remember the answer to that for governmental entities.
Because I think the way it was written was leaving us with the impression that governmental entities weren't going to be able to
Yes.
take advantage of the tax credits.
That's
And
correct.
I'm not sure that we've gotten clarity on that from either the Department of Labor or the IRS yet.
Yeah, but they were not allowed to get the tax credits like a non-governmental entity.
Yeah, like the private employers.
Like private employers. Yeah.
So, I mean, I don't know what they're thinking though, if they're requiring the cities to, pay all this paid leave, or the counties pay all the paid leave, And then, who's going to foot the bill for that? Because the feds are footing the bill for the private employers, but I don't know what they're going to do with the public employers.
I haven't seen that yet.
Now I'm going to skip over. We got through all the questions that were submitted ahead of time, so I think we're making good time here. It's 12:36. I'm going to jump over the questions in the chat. Many restaurant employees are out of work because dine-in restaurants have been forced to close and governments have issued stay-at-home orders. Are these employees considered to be in quarantine or isolation or otherwise eligible for the purposes of the emergency sick leave? The answer to that is no. Again, if the business is closed, either because there's no business or because they've been forced to close by the government, then the employees can apply for unemployment, but they're not going to be able to use this paid sick leave. And if the employers go ahead and give them the paid sick leave, and then try and get tax credits for it, that's going to be a problem. They could probably take the tax credit, but if the IRS ever comes back to audit it, they're not going to be able to substantiate it, and they're going to be subject to having to repay it and probably penalties and interest. Describe the differences between layoff and furlough and how it applies to eligibility for these programs. As I mentioned earlier, there's no difference. It's just what you call it. It means the same thing. Compensation is limited to the first $100,000 of compensation under the PPP loan, or is the employee simply excluded if they make greater than $100,000? What is the obligation of the employer to apply for these programs? Is there liability from employees for not doing so? I think these are questions that are dealing with the CARES Act, that latest legislation that was passed. And Eric, do you know the answer to this?
No, that's in the CARE Act, and I don't know the answer other than having just read a little bit about it. We didn't dive into it like on the employee benefit side, so I don't know the answer.
Okay. Next question.
Next one's up my alley, I guess, so I'll read it. Retirement contributions apply to wages paid under the leave, but can flex contributions be adjusted to reduce earnings, 2/3 pay versus 100%? And I think that's a good question, and it goes to several issues. One thing people have asked is, depending on what's going on, is this a change in status under a flex or under a 125 cafeteria plan? And it depends on the situation. If somebody has a reduction in hours and they're continuing to get paid, they can, then they've got a change in status event, and they can adjust what's taken out of their pay for medical or dependent care plans, whatever it might be, or other premiums that they're paying. But for somebody that just is out on and they're getting paid leave, even though it's a lesser amount of paid leave, or the sick leave or the emergency leave, the question is that a reduction in hours, or are they just out on a paid leave? And that brings up something worth talking about, which is the way all of these, what they call welfare benefit plans, are drafted, and what the rules are in the plan. Anybody that offers a welfare benefit, not just the flex, but medical, dental, vision, short-term disability, long-term disability, group-term life, there should be a written ERISA document with your rules in it. Sometimes there isn't one, and you got to go find the rules written in an employee handbook. But in the document, it will usually address certain things, one of which is, how are you going to handle benefits when somebody's out on a leave? Normally, if somebody's out on a paid leave, benefits just continue. Now, if they're out and they're not getting paid at all, how do you pay for those benefits? And so there's sort of three scenarios to look at. If somebody is under a cafeteria plan and welfare plans is out under a paid leave, they're getting paid and they should be able to pay their benefits. If they've had a reduction in hours, then they may be able to change their elections to take less out of their paychecks to pay for lesser benefits. If they haven't had a reduction in hours, but they've had a reduction in pay, they're a little bit in a bad position, and we're waiting for guidance on that. If somebody's out on a family FMLA leave under a plan, and under the rules under FMLA, you have to continue their benefits for 12 weeks. Now, we've had an additional FMLA event added to the list with the person who stays at home with their children for school as a result of all this, but it's still FMLA. They get 12 weeks of coverage. And under FMLA, there's special rules that you're supposed to, you don't change their elections. You keep everything going as if they were still there. And you can work out how you're going to collect the amounts they're supposed to pay, whether it's when they return or on an ongoing basis while they're out by writing a check back. But it's not a change of status. One of the issues we've encountered is, what about somebody that goes on flat out unpaid leave? And there's a bigger issue that's come up, which is a lot of plans say if somebody's on an unpaid leave, then they lose coverage under the employer's plans after a short period of time. Sometimes it's the end of the month. Sometimes it's 6 weeks. Sometimes it's 30 days. And a lot of our clients are saying, that's a really short fuse to cut off benefits, force employees over to COBRA on the COBRA benefits and make them lose the other benefits. So a lot of people are amending their plans temporarily to allow unpaid leave to continue for maybe leave them on benefits for up to, say, 90 days before they have to lose their benefits entirely, which if you're on an unpaid leave that's not a family medical leave could happen. So there's a lot packed into that. And we're still waiting for a little bit of relief in answer to the question itself on change in family status or change in status rules, because some people could get burned and not be able to adjust their salary, adjust their withholding out of their pay under the current cafeteria plan rules. What's the next question, Jim? Is that you or me?
Oh, maybe both of us. Form 941 for the first quarter will be changed to reflect tax changes, or did I misunderstand the answer? Doesn't it start on April 1st? It's kind of an interesting question because my understanding is that, okay, the paid leave can start to be provided on April 1st. So let's say that you provide the paid leave for less than a week, and then you have a payroll deposit hit that includes first quarter taxes. I think that you're going to be able to offset against that payroll tax deposit, which is going to then be reported on the first quarter 941. Yeah. Is that what you think is going to happen, Eric?
Yeah, that's what I think is going to happen, exactly. Now, we've skipped a question there, Jim. One right above it. Paid time off and FMLA are subject to 6.2% employer/employee tax. Thomson Reuters was saying the other day that these wages are not subject to Social Security, which doesn't make sense to me. That's what somebody said. And
interesting. I don't have that question on my screen.
I have it on mine, but it doesn't. It doesn't make sense to me either, because it sounds to me like any kind of paid leave is pay. It's just so I'm not aware of any special tax treatment to exempt it from Social Security. I just don't.
Yeah, I think that the confusion may be that the statute talks about the tax credit being taken against the Social Security taxes that are owed, not Medicare, not federal income tax. But what they're doing with the to help with cash flow, I think, is on the payroll tax deposits. You can offset against any of those taxes that are being deposited for the federal government. So that may be what that question was getting at.
Right.
Because the next question here from Jane Elward, did I understand correctly that the credit is also against the federal withholding and Medicare portions on 941? And yes, that's correct as far as your payroll tax deposits. I don't know what they're going to do. Because the statute itself, as I said, says the tax is credit. The credit is applied to the Social Security tax. So we'll see how that works.
And I think the statute is intended to just create a mechanism to get cash into the employer's bank account.
Yeah.
Hopefully they'll still make it good on the calculations of Social Security.
Yeah. And the other thing to note is that it's theoretically possible that an employer might pay out more in paid leave than they're supposed to deposit for payroll tax purposes. So if that, like for instance, let's say that they paid out $10,000 in paid leave, but are only going to be depositing $9,000 for payroll taxes. Well, they're not going to deposit anything for the payroll taxes. It's going to take an offset against it. They can then apply for a refund from the feds for $1,000.
Yeah, it's going to be an expedited refund process.
And then there was a follow-up question here. So did I understand correctly, this is against the federal withholding and Medicare portions on the 941. If so, the employee gets credit for the FWH, but federal withholding, but doesn't pay it in. Why wouldn't we all increase FWH?
I mean, that's an interesting manipulation. I bet you we'll see some guidance on that very quickly.
Yeah. Next question. How does an employee's accumulated vacation and sick time interact with the 80 hours of sick pay? Okay, so when an employee wants to take time off, let's say it's for a qualifying reason under the Paid Sick Leave Act that gives you the 80 hours of paid sick leave. The employee, I mean, if the employee's got sick leave or vacation or PTO out there and wants to use that first, then it's the employee's choice. If the employee wants to use the new paid leave, it's the employee's choice. The employer cannot force the employee to use up the regular paid leave in lieu of using the new paid sick leave, and they can't force them to use the paid sick leave in lieu of using the regular leave. It is possible that if the employee is getting 2/3 pay under the new law, the employer can allow them to top off the tank and basically get the rest of their pay, the 1/3 that they're not getting paid. They can have that paid through their regular paid leave policy. What you can't do is double dip. So if the employee is taking paid leave under the new law, they cannot also take paid leave under the employer's regular paid leave policy. May I take paid leave to take care of my kids in this summer? I don't think that's going to be allowed unless the reason you're taking it is that their care provider is no longer available. One question that I've had some clients ask me, and I don't know the answer to, is, okay, so what if like grandpa or grandma was taking care of the kids for free? Now that doesn't, I mean, grandpa or grandma is now quarantined, and and if the kids still need to be taken care of, can mom or dad stay home and get paid sick leave? And the answer to that's no, because again, grandma or grandpa wasn't being paid before. But I mean, you still got to have somebody to take care of the kids. So what if you try and go out and enroll your kid at a daycare provider, but the daycare providers aren't accepting new kids? What's going to happen there? I don't know. I mean, is paid leave going to be available at that point? I don't know. I think maybe that's something that the Department of Labor will address either in the FAQs or in some regulatory guidance, but we'll see. But as far as the summer leave, I mean, if the kids were normally being watched by family for free during the summer, I don't think this new law is going to allow mom or dad to stay home and take care of them during the summer and get paid leave for it. Next question. If you have an employer that is allowing all full-time staff to telework, but a part-time employee that cannot telework due to job requirements, that employee would need to file for unemployment, not receive COVID-19 FMLA, correct? Yes, that's correct. If the employee if there's no way for the employee to telework or can't do the job at home, then that's not going to be paid leave. That's going to be unemployment. Not allowing one employee of 5 to telework isn't a violation of these DOL requirements, correct? Yeah, that's correct, because again, these requirements don't put any limitations, restrictions, or obligations on employers to allow telework or not to allow telework. What exactly do you as an employer get as a credit? Gross paid leave wages plus employer FICA tax match only? Or do they get credit for gross employee withholdings, FICA and federal withholding, and employer match FICA? Well, I think the answer to this, Eric, tell me if you disagree, but I think the answer to this is that the employer can get a credit for the gross amount of the wages that it's paying as paid sick leave, plus the portion of the group health plan premiums that the employer is paying for purposes of the paid leave. So for instance, if the employee takes 2 weeks of paid leave at full pay, then the employer can get a credit for the 2 weeks of full pay plus a prorated portion of that month's premium for that employee.
Health insurance, that's correct.
You agree, Eric?
Yes.
Okay.
But the question also had, do they get the employer's share of FICA?
No, I don't think so. I don't think you get a credit for the employer's share of FICA. I think it's only for the wages that are paid to the employee along with the healthcare premiums. And the statute specifically calls out those two things. So I think the employer is still going to be on the hook for its share of FICA and isn't going to get a tax credit. This was the last question so far. If you got more questions, shoot them on the chat. The technical explanation of Division G from the Joint Committee on Taxation issued March 17th stated on page 22, quote, that the wages paid under the new law are not considered wages of the employer for purposes of FICA tax. As a result, no federal employment taxes will be collected on such amounts from employers and employees to be contributed to the OASDI, close quote. I've been trying to get confirmation of this since I read this with no luck. Well, I mean, I guess if I hadn't read that or heard about that, I guess if that's true, then the answer that we just gave to that last question was wrong.
But the question is, I think the question is, that 31720 was pre-passage of the act, right? So I don't know
Yes.
what draft that's in. So we need to follow up with that on our follow-up questions.
Yeah, I mean, the IRS is still working on regulations regarding this thing. They did issue a notice last week, I think just to let people know that they're working on the regulations and that they were going to be able to take the credit against the payroll tax deposits. But yeah, that'd be great if they issue guidance that says that employers don't owe their half of FICA.
I haven't seen that, so I don't know if that fell out in the technical explanation or not. But we'll follow up with that and put the word out on it. One other thing I wanted to mention really quick is, again, with regard to your health insurance and all of your employee benefits. Many of the plans employers provide have rules in them, and they're supposed to follow the rules, and they're supposed to be written down. And one of the set of rules is that, often they say the eligibility condition to be in a plan typically is a regularly scheduled work week of 30 hours or more. That's pretty common since Obamacare. So to get a benefit, you have to have a regularly scheduled work week of more than 30 hours or more. We're going to start seeing, and we are seeing, a lot of people who are reducing hours. And now people's regularly scheduled working week has dropped below 30 hours. And so what happens is that would mean if you left the plan documents and the rules and your benefit plans intact, people that are still employed but are working less would lose coverage typically by the end of the month. Now, Blue Cross and a lot of the health insurance carriers said, we'll lighten up on that. And if you want to change your rules in your plan, do so. And you can allow people who have been previously covered under the plan to continue as long as they pay premiums, and lower the threshold below 30 hours as a regularly scheduled work week for a period of time. So a lot of clients we're working with are doing a temporary amendment to not be so strict with their for people previously in their benefits, so that they don't have to cut them off. So that's something to really pay attention to. Because you don't want to have rules in your plans that accidentally kick employees out of health insurance and other benefits and throws them into things like COBRA if you don't have to or don't want to. So
go ahead, Eric.
Go ahead, Jim. I think that was the last question.
I had another thought I wanted to share with you. Earlier when we were talking about taking the paid leave intermittently, what I told you is that it's up to the employer and the employee to agree on whether it can be used intermittently for taking care of the kids. Now, if you're dealing with a situation where the employee is, say, self-quarantined at home, or they're subject to a quarantine or isolation order, the employer and the employee can also agree to allow intermittent leave in that situation from home, okay? So, you know, if you got somebody who's self-quarantined, they may actually not be sick and able to work, in which case they can just, you know, they can work at home and they're not taking any paid leave. But if they're not able to work part of that time, the employer could allow them to do it intermittently. What you can't do, though, is a situation where, like, you say to the employee, you know, say your employee comes to you and says, okay, yeah, I have to self-quarantine. Here's the note from my doctor, you know, and it says I'm going to be there for the next 2 weeks. And then the next day, the employee calls up and says, you know, I'm going to go ahead and come on into work. The Department of Labor is very clear that that's not allowed. And, you know, the rationale for this is, look, if you're sick enough or there's concern enough that you should not be at work because of a quarantine or self-quarantine or something like that, then you need to stay away from work, because the whole purpose of this law is to stop, or at least one of the big purposes of the law is to stop the spread of this terrible disease.
Something I did want to point out, I know that there was that question asking about the stay-at-home order and pet grooming services and whether or not that's essential. So just a side note, doesn't have anything to do with what we're talking here today, but if you guys or you have clients that are curious about the governor's recent stay-at-home orders, the executive order lists out what they consider essential functions, but if you have questions on that, they've set up an email address that business owners can send an inquiry to get clarification. So I've included that in the chat for reference, should you need to reach out for further clarification on what's essential and not essential. But with that, Eric and Jim, it looks like we made it through all of our questions and we made good timing. So nice work. Thank you so much to you both for taking the time to give those thorough answers. It's very valuable, provided a lot of clarity for myself, and I'm sure those on the call as well. So with that, I just want to encourage folks on here, if you have any follow-up questions, just go ahead and post them on Exchange, our community platform, and we'll try to get those answered from there. Thank you all for spending your lunch hour with us, and a big shout out to Eric and Jim. And with that, that ends our virtual Q&A. Stay safe and stay well. Goodbye.